Hello, I am Madhubanti Sadhya from the National Law School of India, University, Bangalore, and in today's discussion, I will be looking at the right to information and freedom of information laws in India, United States of America, and United Kingdom through a comparative lens. We'll make the comparison on the basis of certain parameters, such as what were the events that led to the enactment of the different laws, how is information defined under each of these laws, who are the public authorities or public agencies from which information may be sought, who are the people who are eligible to seek information under these laws, what is the appeal procedure, so on and so forth. Now, moving on with the discussion. From all the discussions that have happened through this course, it is fairly evident that right to information or freedom of information is a human right. And it has been developing at a strong pace only recently. But it is not a very new concept. The roots of freedom of information principle date back to the 18th century, which is popularly known as the Age of Enlightenment. The world's first freedom of information legislation was adopted by the Swedish Parliament in 1766. And it was with the efforts of the politician and thinker Anders Chydenius from the Finnish city of Kokkola, who played an extremely important role in creating this law. The key achievements of the 1766 Act was the abolishment of political censorship and the gaining of public access to government documents. Although the innovation was suspended from 1772 to 1809, the principle of publicity has since then remained central in the Nordic countries. Over recent decades, Anders Chydenius's legacy has received increased recognition globally, especially with the creation of United Nations and international standards on human rights. The right to information has begun to spread. Freedom of information is, in a way, recognized in international law. And if I were to pinpoint the article, it is Article 19 of both the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights that provides every person with the right to seek and impart information. In 1980, the Commonwealth Law Ministers' Meet stated that public participation in the democratic and government process was at its most meaningful when citizens have adequate access to official information. Now, the move for freedom of information has also been advocated by UN Convention Against Corruption in 2003, and the UN Convention Against Corruption acts as a foundation for the rest of the countries to develop legislations in this field. Now, freedom of information may have had a very early start and dates back to the 18th century, but it has been developing rigorously in the recent times, and there are over 100 countries that have enactments relating to freedom or the right to information. Now, let us look at the three legislations that we want to discuss. First, we will look at how the different laws were enacted. Now, looking at the Indian law, the Right to Information Act was enacted in 2005, and we know that the Constitution of India does not explicitly recognize the citizen's right to information, but there have been a series of progressive judgments by the Supreme Court that have recognized this right as an extension of the fundamental right of freedom of speech and expression, which is recognized under Article 19(1)(a). But it was only a powerful grassroots movement which was well connected or championed by the national advocacy groups that led to the enactment of the 2005 Act, the Right to Information Act. Now, public demand for the RTI Act, coupled with the support from the Congress-led United Progressive Alliance government, which came to power in May 2004 and was headed by Dr. Manmohan Singh, led to the enactment of this legislation in May 2005. It has been preceded by a number of state RTI laws and at the national level by the Freedom of Information Act of 2002, which was way less ambitious and ineffectual. And therefore, the need for a new law was felt and the Right to Information Act was passed. Now, much has already been discussed about how this act was enacted. If we have to actually point out some of the core objectives that this act seeks to fulfill, it would be four. First, to create an informed citizenry. Second, to ensure transparency of information in government functioning, which is extremely vital for the functioning of the government. Third, necessary information to contain corruption. And fourth, to hold government and its functionaries and instrumentalities accountable to the governed. The next law that we will be discussing is the United States Freedom of Information Act and how it was enacted. Now, this is one of the first laws to be enacted on freedom of information, and it dates back to 1966. And the act was finally signed in 6th September 1966 by President Lyndon B. Johnson, but the passage of the act was not very easy, because the efforts for the enactment started way back in 1955, when Representative John Moss created a committee to advocate for the creation of right to information. In his pursuit, John Moss brought together several politicians, journalists, attorneys, and civil society organizations, but it took more than a decade's effort to pass the bill. Early supporters of the Freedom of Information Act included the American Bar Association, the United States Chamber of Commerce, various committees composed of journalists, editors, and broadcasters. But the act faced very strong opposition from the Johnson administration and the executive branch of the government, which included the Department of Justice, the United States Legal and Law Enforcement Department. And the opponents of the act objected the legislation on the ground that it would unconstitutionally violate the separation of powers and it would encroach on the executive power and eliminate discretion regarding document disclosure. So they were strongly opposed to the idea of the Freedom of Information Act. But bipartisan support of the bill was very strong, and that ultimately led to the act's adoption. But literally every federal agency opposed it. And so severe was President Lyndon Johnson's aversion to the act that it is said in humor that he had to be literally dragged kicking and screaming to sign the legislation. Now, looking at the United Kingdom's Freedom of Information Act, the first demands for this act rose in the 1960s among professionals who were on the margins of formal political organizations. And these people comprised of lawyers, journalists, academicians, and also backbench members of the two main parties who had very little power to affect government policy. Now, the central concerns of these groups were the threats to individual liberty which was being posed by the growth of administrative state and the inability of the political mechanism which was then existing to adequately address these concerns. From the early 1970s, this group of people were joined by campaigners of public interest, environment, health and safety who wanted to overcome the spillover effects of large-scale industrial production. And in 1984, these two groups created an alliance which was called the Campaign for Freedom of Information. Now, although there was a long history of mobilization and support from a wide variety or a wide range of social and political interests, the success of access to information laws in the United Kingdom ultimately dependent on the cabinet's receptiveness to such demands. And in 1996, when Tony Blair, the then opposition leader of the Labour Party, personally associated himself with the idea of the Freedom of Information Act at the CFOI's annual awards ceremony, that they started to see some kind of hope that such a legislation may be passed. So, in a way, it can be said that United Kingdom's Freedom of Information Act was passed by the British Parliament in 2000 as a fulfillment of the Labour Party's election manifesto of the 1997 election. Now, let us look at some of the important definitions and the coverage of the three legislations. To start with, we will look at the Right to Information Act of India and see how the word information has been defined. Now, information is defined under Section 2F of the Act as material in any form, including records, documents, memo, emails, opinions, advice, press release, circulars, orders, logbooks, contracts, reports, paper, samples, models, data material held in any electronic form, and information relating to any private body which can be accessed by a public authority under any other law for the time being in force. So if you look at the definition, it is fairly evident that the word has been very broadly defined, and it not only includes any kind of records and documents that the public authority or agency in question has at its disposal, but it also includes contracts or any kind of opinion or advice that the authority has given. So it is indeed a very, very broad definition. Now let us look at what the Act means by right to information. Now we know what information is, but what do we mean by right to information? The Act defines right to information as a right to inspect, work, document, records, taking notes, extracts or certified copies of the documents or records, taking certified samples of materials, and taking obtaining information in the form of diskettes, floppies, tape, video cassettes, or in any other electronic mode, or through printouts where such information is stored in a computer or any device under Section 2J. Now we know that diskettes, floppies, video cassettes have gone out of use. They were in use when the Act was passed in the year 2005. So basically, it is not only obtaining information, it can be accessing information or inspecting any kind of work. If you want, it can also mean taking notes. So information in any kind of format which is stored either in the soft copy or in the electronic mode can actually be accessed. Now, who is a public authority and why is it important to define public authority? Because these are the very bodies who fall within the ambit of the Act from whom information may be sought. The Act defines public authority as any authority, body or institution of self-government established or constituted under the Constitution of India or by any law made by Parliament or state legislature, as well as any body owned, controlled or substantially financed, including non-governmental organizations, substantially financed by funds provided by the government either directly or indirectly. So basically all kinds of constitutional bodies, then public sector undertakings, government companies, any body, local self-government bodies, all of this fall within the ambit of public authority. So it covers all courts, parliament, legislative assemblies and councils. But the Act does exempt certain authorities from the definition of public authority under Section 24 of the Act. So security and intelligence agencies established by the central government have been exempted from the coverage of the Act. And the Schedule 2 of the Act lists some of these bodies. For instance, the Intelligence Bureau, the Research and Analysis Wing of the Cabinet Secretariat, then Directorate of Revenue Intelligence, Central Economic Intelligence Bureau, Directorate of Enforcement, then Narcotics Control Bureau, or the crime branch of the CID, all of them have been exempted from the Act. So no public can actually ask for or exercise their right to information against these bodies. Now, the law does not specifically cover private bodies, but it does enable citizens to access information about private bodies if such information is accessible by the public authorities. Like, for instance, in case of a public-private partnership, if any information is available about a private company that is required to be submitted to the government is available to citizens under the RTI. So any kind of public-private partnership, then when there is a private party involved in that public-private partnership, then that information about that private company can actually be accessed by the citizens under the RTI Act. Now, who can seek information under the Act? The Act is basically available for the use of only citizens, because the long title of the Act, the opening words of the Act itself says that it is an act to provide for setting out the practical regime of right to information for citizens to secure access to information under the control of public authorities. So that is how the long title of the Act has defined its scope. So the Act is only accessible, or only citizens can basically seek information under the Act. Now, let us look at the United States of America and see how has the word information been defined. So, entities who are subject to the Freedom of Information Act can make available for disclosure information in the Federal Register. Now, what is the Federal Register? It is a register which publicizes federal government rules, proposed rules and notices. So, according to the Freedom of Information Act, the Federal Register, in the Federal Register, the different bodies must publish descriptions of the agency's central and field organization, then description of the places, employees, members and methods that an agency uses to obtain information or submit requests or obtain decisions, then statements about the general course and method of how an agency handles its functions, including the nature and requirements of all available informal and formal procedures, then what are the rules of procedures of that particular public agency, then descriptions of the forms which are available or the places where these forms can actually be obtained and accessed, then instructions regarding the scope and content of all reports, examinations, then rules of general applicability which are adopted by that public agency or which are being authorized by law for that public agency, then statement of general policies or interpretations of general applicability which have been either formulated or have been adopted by the public agency, then any kind of amendment, revision or repealing of any of these information. Now, aside from these body or these information which should be published in the Federal Register, the agencies must also make records available for inspection and copying by the public. So there are certain information which has to be made available for the public, and they include final opinions and orders which may have been made in adjudication, including the concurring and the dissenting opinions. So if any kind of order has been passed by a public agency, then what were the opinions, what were the orders made, what was the concurring opinion, what were the dissenting opinions, all of this has to be published. Then policy statements and interpretations that have been adopted by the agency but that have not been published in the Federal Register. Then administrative staff manuals and instructions to the staff that may affect the members of the public. Then copies of all previously released records that may become or are likely to become the subject of subsequent requests because of the subject matter that they deal with. Then a general index of previously released records. Now, the Freedom of Information Act is not limited to records in an agency's possession only. So, if another entity is housing an agency's records, then even they are subject to the Freedom of Information Act. So, records which are held or maintained by any private company on behalf of a government entity are also subject to the Freedom of Information Act in the United States of America. Now, who is a public agency? Now, in India, under the Right to Information Act, we refer to these bodies as public authorities, and in the US, they are referred to as public agencies. Now, we know that United States of America is a federal state, and they have two constitutions, the federal constitution and the state constitution. So, there are also two citizenships, the US citizenship and the respective state citizenship. So therefore, the United States Freedom of Information Act applies to all agencies of the federal government. So they include executive departments, bodies, boards, public corporations, regulatory commissions, all of this of the federal government. Now, executive and military departments, then government corporations and government control corporations, other executive branch establishments, then certain parts of the executive office of the president and all independent agencies, they are all subject to the Freedom of Information Act. But there are certain exemptions as well. Requesters have access to records held by most, but not all federal government agencies. Now, there are certain key actors that are not subject to the Freedom of Information Act, and these bodies include the Congress and its support offices and agencies, such as the Government Accountability Office, then the Government Printing Office, and the Library of the Congress, the federal courts, and parts of the executive office of the president that function only on the only to advise and assist the president. Now, private citizens and corporations are also exempt from the Freedom of Information Act, even if they have received large government contracts or perform quasi-governmental functions. So one of the examples of this would be the private prison industry. So although these bodies do receive government grants and contracts and they perform quasi-governmental functions, but they do not fall within the ambit of the Freedom of Information Act. Now, who can seek information under the Freedom of Information Act? Anyone may file an Freedom of Information Act request. So, judicial and legislative interpretations of the term person includes American citizens, residents, foreign nationals, minors, prisoners, corporations, the media, universities, and other organizations. So basically, there have been various judicial pronouncements where the question came up as to who do we understand by the term person. So person actually includes not only American citizens but also foreign nationals. Now, in order to file a request, a person must follow the proper filing procedure and reasonably describe the information that they are seeking. However, the agency is not required to create documents or records in order to fulfill a request under the Freedom of Information Act. And what is the format in which the information will be provided? The public agency, as the Act addresses, are to provide information for public inspection in electronic format. If the requesters want, they can also specify the format in which they would want the information. But agencies are supposed to dispense the information in the format requested as either paper or electronic copies, if the record is in a readily producible in that format. So if the format is such which is readily producible and that is exactly the format in which the person seeking information has asked for it, then it will be made available to the person seeking the information under the Act. In the United Kingdom, Section 84 of the Freedom of Information Act defines information as any information recorded in any form and held by the public authority. So basically, the Act bestows upon the public in the country the legal right to know about the functioning of public authorities, that is, a general right of access to information held by public authorities. The right allows people to do two things. First, to ask whether the public authority concerned has the information that the person specifies, and secondly, if it has the material, to give copies of it in the form that the person wants. That is, it could be photocopies or electronic files, provided the information is not legally exempt from disclosure. Now, under the UK law, that is the Freedom of Information Act, the term public authority has been used to designate all kinds of bodies from whom information may be sought. Now, the Freedom of Information Act is applicable to all public authorities at the central and the local level, and the bodies have been identified under Schedule 1 of the Act, and the Secretary of the State has the power to amend the list to also include other public authorities, including those who provide services under contractual obligations to the public authorities. Now, the public authorities in Britain include all government departments, NHS, bureaus, boards, public sector corporations, schools, colleges, universities, including legal entities like companies and councils. The Act technically covers or affects 1 lakh public bodies, and the authorities covered are explicitly identified in Schedule 1, and which also specifies that certain bodies are covered only with respect to particular functions. So basically, the schedule enlists the different bodies and also mentions the functions with respect to which information may be sought. So all functions of all bodies may not come within the purview of the Freedom of Information Act. Now, Section 84 of the Act also exempts some bodies from the application of the Act, and these bodies include the Security Service, the Secret Intelligence Service, or the Government Communication Headquarters from the definition of government department. And the Scottish political and administrative authorities that are covered by the Freedom of Information Act in Scotland are also exempt from this Act, and an absolute exemption applies to the information held by or related to 13 security and intelligence authorities and their related tribunals and commissions that are there. So even these security and intelligence authorities are exempt from the ambit of the Freedom of Information Act in UK. Now, who can seek information under the Act? United Kingdom is a unitary state, and the Freedom of Information Act is applicable to all British citizens who reside in England, Wales and Northern Ireland. Although Scotland is an integral part of the UK, it has its own Freedom of Information law, which was passed by the Scottish Parliament in 2002, governing British citizens residing in Scotland. So those citizens of Britain, or the British citizens who reside in Scotland, fall under the ambit of the Act which was passed by the Scottish Parliament and not under the UK Freedom of Information Act. Now, the Freedom of Information Act grants the right to know or the freedom of information not just to the citizens of United Kingdom but to every member of the public. And the request has to be in a written format, but email is also entertained. And the applicant does not have to give his or her real name, but contact address in the request is sufficient. And the applicant also need not explain why he needs the information. And the public authority has no right to ask reasons from the applicant. Now let us look at the process of obtaining information under the three legislations. In India, Section 5 of the Right to Information Act provides that every public authority should within 100 days of the enactment of the legislation designate as many officers as central public information officers or state public information officers in all administrative units or offices under it, to basically facilitate the provision of information to persons who request for it under the Act. Each public authority must also designate a senior officer as the first appellate authority who shall be senior to the CPIO or the SPIO, as the case may be, and of that particular public authority. The Central Information Commission or the State Information Commission is the second level appellate authority for all complaints and disputes on the information rights of citizens under the Act. Now, when we look at the process of appeal under the Right to Information Act, this will be a little more clearer. Now, what is the applicant expected to do? The applicant seeking information has to submit a request in writing or through an electronic medium in the official language of the concerned state to which the applicant belongs, or English or Hindi, and state the format in which the disclosure of information is sought along with the prescribed fee. And this application has to be made to the public information officer of the concerned department or public authority. The section, that is section 5, however, provides that the applicant is not required to give any reasons for making such a request, and only such personal information is required which would be necessary to communicate the information. So basically, you need not divulge, the applicant need not divulge his real identity. Any kind of communication or any kind of address that will help the PIO to respond to the request of the applicant is sufficient. Now, what does the information officer have to do? He has to make efforts, and if necessary, he can seek assistance of other public officers to provide the information which has been sought by the applicant. The time limit for this is 30 days. So the PIO has to give information within 30 days of receiving the request. And Section 7 of the Act states that if the information relates to life and liberty of a person, then the PIO has to supply the information within 48 hours. Say for instance, somebody is facing some kind of charge in a case, and if the person could be arrested because the information is not available, then in such cases of emergency, the PIO may have to make the information available within 48 hours. Now, where the information sought relates to any kind of confidential or personal information of a third party, then this particular third party has to make representation to the PIO, after which the officer will decide, considering larger public interest, whether or not the information should be provided to the applicant. So in this case, the public information officer may take a maximum of 40 days to provide the information. The PIO also has the right to deny information, and the grounds for such a denial are provided under Section 8 of the Act. But every denial of information has to be supported with reasons for non-provision of information. So if any kind of information is denied under the Act, the officer has to give reasons as to why the information has been denied. Now, let us look at the law in the United States of America. Now, in the US, every federal agency or public agency has to set up a Freedom of Information Act office to deal with requests for information held by that particular agency. Now, former President Bush had created an executive order which was signed in December 2005, and it was the name of the order was Improving Agency Disclosure of Information. And through this executive order, a position of a Chief Freedom of Information Act officer was created. And what is the purpose of this office? It was basically a high-level official who had to monitor the implementation of the Freedom of Information Act. Now, this very executive order also requires all officials or all agencies to establish one or more Freedom of Information Act Requester Service Center and Freedom of Information Act Public Liaison to assist in Freedom of Information Act requests. So this executive order does make provisions for a lot of offices to be established to facilitate access to information. Now, under the Open Government Act, which was again signed by President Bush in December 2007, an Office of Government Information Services has come into existence in the National Archives and Records Administration. And the task of this office is basically to review agency compliance of the Freedom of Information Act. So this newly established Office of Information Services will mediate to resolve any kind of dispute as non-exclusive alternatives to litigation, so that it does not result, any kind of freedom of information request does not result in litigation. So they will try to look at alternative modes of dispute resolution. Further, this act also calls upon every agency to designate a Freedom of Information Act public liaison who will assist in the resolution of any such dispute. Now, all applications relating to information which are covered within the ambit of the law and those that do not fall under the exemptions are to be dealt with within 20 working days. And an extension of 10 working days may be given in exceptional circumstances, in which case the applicant would be informed of the same within the 20 working days, and the applicant would also be given an opportunity to limit the scope of information required. Now, what are these exceptional circumstances or unusual circumstances? Now, unusual or exceptional circumstances have been defined as the need to search and locate the requested information due to voluminous records, or because the information needs to be obtained from a different agency. So in case of these unusual or exceptional circumstances, the information will not be provided within 20 days, and an extension of 10 days would be required. And within the first 20 days only, the applicant would be informed that this further period of 10 days would be required to provide the information. Now, if there is any kind of delay, then an applicant can appeal to a higher authority or court. And if the higher authority or court finds reasonability in the agency's contention, then such extension of time may be granted to provide the information. So if any kind of information is likely to affect the personal liberty and safety of a person, then such information is to be provided for by the agency on a compelling need basis within 10 days. So we've seen in the Indian law, it is within 48 hours, but in the US, this information, if it affects any kind of personal liberty or safety of a person, then the US law gives a time limit of 10 days to provide this information.